Morning, Judge.
Good morning. Well, that worked all right. How are you today?
I'm doing pretty well. How about yourself?
Hanging in there. A rough start to the day.
You said you had a rough start to the day?
Yeah. A couple of friends of mine, their husband and wife, they had been doing issues, and he passed away. Like I think it was like a Friday, and then she passed away today. So,
Oh my goodness, I'm sorry to hear that.
in one respect, it's very romantic, but on the other hand, it's a big loss.
Yeah. Yeah, I am sorry to hear that.
So, how was your weekend?
The weekend was pretty good. My kids were with me this past weekend, so we just spent a lot of time around the house and having leftovers from Turkey Day, and it was nice. It was nice to just have kind of a low key time around the house, just watching movies and picking up and stuff like that. So
All of your children?
my daughter's 18th birthday is today.
You have an adult?
So she's 18, and then I've got two boys that are 15 and 12.
You have your hands full.
I do. Yep, and they don't like the distance learning, or the fact that they can't do as much as they used to do before this pandemic got serious.
Right.
Yeah. But but they also understand. I mean, the nice thing is that my kids do take it seriously, so I'm thankful for that.
Yeah. They're not the only ones who are tired of it, but
Right.
it goes.
Yeah, that's definitely the truth. Morning, Leah.
Good morning, Andrew.
Morning, Leah.
Good morning, Judge.
Good morning. This is John Voorhees. Can you hear me?
Yeah, we can hear you. Can you hear us all right?
I don't want to be muted.
I can hear you fine. I'm sorry, Judge. I'll be observing today, but my client, Lewis
How do
Taylor,
I do this?
may want to join and observe at some point, but I would try to set that up during a break, like the noon hour.
John, I can send you a YouTube link that you can share with Lewis, that he where he can watch the proceedings at any time he wants to.
Oh, that'd be great. I didn't know about that.
Yeah, I'll send it to you.
Thank you. And I'll just mute my mic and I'll just be observing. Thanks.
Unmuted.
Do I have to increase the sound?
Oh, yep, you are.
We can hear you, Tom.
All right. Thank you.
You just hit that. Okay.
Morning, Katie.
Good morning. Good morning, everyone.
Good morning, Katie.
Good morning, Ashley.
Morning, Ashley.
Can't hear you.
Oh, okay, we have to wait for Ash. She had to step out.
Nope, still can't hear you,
We
Ashley.
still can't hear you. There you go.
You can hear me now?
Yes.
Yes.
Okay, perfect. Thank you.
I believe everybody's here. Is everybody here? Okay, it's scheduled to start at 9 o'clock. Katie, read the case.
Okay.
The case today is in the interest of the St. Croix tribe versus Elmer Emery. Case number 20-CB-203. Presiding today is the Honorable Judge Stephen Woolley.
Call the court to order and ask for appearances.
Your Honor, I'm Tom Mulligan. I'm not really appearing for this due to the automatic stay of the federal court. I will be monitoring it, and that would be the extent of my involvement. Elmer Emery, having not been subpoenaed, is not here and not expected to be here.
Mr. Adams? Make your appearance, please.
Your Honor, I mean, this is,
I'm asking for appearances.
oh, pardon me?
I'm asking for appearances.
Yeah, Your Honor, this is attorney Andrew Adams, and I'm appearing on behalf of the St. Croix Chippewa Indians of Wisconsin.
Anyone else appearing with you?
Yes, I've got Leah Jers, who is an attorney at my law firm, and then also Ashley Duffy is here, who is the general counsel for the St. Croix Chippewa Indians of Wisconsin. They're both appearing on behalf of the St. Croix Chippewa Indians of Wisconsin with myself.
All right, thank you. Mr. Mulligan seems to be saying that he's here, but he's not here. So how does the tribe want to proceed?
Well, Your Honor, Attorney Mulligan also stated that the defendant in this case, Elmer Emery, is choosing not to appear before the court. And Your Honor, I'm unfamiliar with the concept that that Mr. Mulligan is arguing that we were required to subpoena Mr. Emery for his appearance today. He's the defendant in the case. He was properly served with the complaint. His attorney has been in receipt of all of the filings that we've made in the case. And Your Honor, due to Mr. Emery's choice not to appear at today's hearing, the tribe would respectfully move that the court issue a default judgment against Mr. Emery in accordance with Section 311 sub B of the St. Croix Tribal Court Code.
Mr. Mr. Mulligan, I'm going to give you an opportunity to respond to that.
Well, Your Honor, I don't know that I can by virtue of the fact that I do not want to violate the automatic stay from the federal court. For me to respond could be considered to be an act of recognition that this court presently has jurisdiction, which we do not believe that at the time the court has jurisdiction due to the automatic federal bankruptcy stay in this matter.
No, you've told me that twice now. And you haven't shown me anything that says that. Not made any references to any particular code of laws that says that. You have not explained it to me any kind of detail that says that. Okay, Mr. Adams. I'd ask the parties to Mr. Mulligan to give me a brief that explains to me the position of why this court should have to do an automatic stay. He has failed to do that. You then, Mr. Adams, filed a letter to the court that is dated November 27th. And you did talk about the bankruptcy code and how it works, but you had made a statement on page 2, the third paragraph in, where you talked about the various things that 11 U.S.C. sub 362 sub A sub 6 talks about, and that which is basically several exceptions to the general provisions of, I guess, staying bankrupt in bankruptcy proceedings. Would you expound on that, please?
Yes, Your Honor. So 11 USC section 362 sub A sub 6 states that that the federal bankruptcy code does contain a provision that provides for an automatic stay of certain proceedings against a debtor once the debtor has filed for bankruptcy. And these include any, quote, any act to collect, assess, or recover a claim against the debtor that arose before the commencement, of the case under that title. I mean, the tribe will totally stipulate that, Mr. Emery has every right as an American citizen to file for bankruptcy protections under 11 USC section 362. But Your Honor, it's not as simple as saying that because Mr. Emery filed for bankruptcy that these proceedings in the tribal court are automatically that are not actually the stay definitely exists, right, Your Honor? I mean, it's there. It's just that the problem for Mr. Emery is that the bankruptcy code also provides for explicit exceptions under that general prohibition that is outlined in 362 sub A6. And those are contained in 11 USC section 362 sub B4, which states that actions to establish paternity, to dissolve marriages, to revoke professional licenses, and most importantly for the tribal court's consideration are actions that are brought by a governmental unit. And these, Your Honor, include, quote, to enforce such governmental units or organizations' police power and regulatory power, including the enforcement of a judgment other than monetary judgment obtained in an action or proceeding by the governmental unit to enforce such governmental units or organizations' police or regulatory power. And I mean, to take it a step further, Your Honor, and I tried my best to outline this in the letter to the court. You've got the bankruptcy code recognizing that governments can continue to pursue actions related to their regulatory and police powers. And then you also have, Your Honor, various federal circuit courts that have agreed that there is nothing in the bankruptcy code that waives a tribal government's sovereign immunity. And so the position that puts Mr. Emery in this at this point, Your Honor, is that it's totally within Mr. Emery's right not to participate, in these proceedings, but there are repercussions that come with that. And if Mr. Emery felt so strongly about his position that this court lost any type of jurisdiction over the case or should be automatically enjoined from moving forward, then Mr. Emery also had, Your Honor, every opportunity to seek a temporary restraining order from a federal court to enjoin this court from moving forward. He hasn't done that, Your Honor. He and his attorney have not provided any clear specifications under the law. I would argue, Your Honor, that what Mr. Emery and his attorney provided on Friday at noon for the filing deadline is wholly defective. There was no cover letter explaining what that filing was. It was some filing to a federal court, to a foreign court that was not, that wasn't, I mean, it was filed, it was provided to this court, but it provided no explanation. It requested no type of action from this court, Your Honor. And so, Your Honor, the tribe takes the standpoint that it is a sovereign government that has a relationship with the United States. The St. Croix Chippewa Indians of Wisconsin fit the governmental definition under the bankruptcy code. And because of that, Your Honor, and because this action can clearly be articulated as one where the tribe is exercising its regulatory and police powers, Your Honor, we respectfully move that this court issue a default judgment against Mr. Emery, hold any execution of any damages in abeyance until Mr. Emery's bankruptcy proceedings have been finalized in Madison. And but as part of that default judgment, to disqualify Mr. Emery from being an eligible candidate in future St. Croix elections for office, Your Honor.
Okay, I want to be real clear on this. You're saying that Mr. Emery's failure to appear means that this court can find him in default. And I'm in agreement with that. So then you're talking about holding something in abeyance. When you're saying that the court then would not address the monetary portion of this that would go with that default judgment. Is that correct?
Your Honor, I take the standpoint that this court can, because of his failure to show and to defend himself, Your Honor, Mr. Emery is essentially forfeiting arguments concerning his defense. So, Your Honor, I take the standpoint that in the default judgment, you could identify the amounts that we're alleging that Mr. Emery misapplied funds from the tribe and order restitution. But the piece that I'm saying is that the tribe would be willing to hold in abeyance any like writ of execution against Mr. Emery out of respect to the federal court. But Your Honor, there is nothing in that bankruptcy code that divests this court of jurisdiction over this case.
Okay, and I'm in agreement with you on that point about jurisdiction. On the point of issuing an order that Mr. Emery is no longer able to run for office for St. Croix. There's a mere fact that I find him guilty of the 16 counts. Is that sufficient to issue that order?
Yes, Your Honor. The default judgment against Mr. Emery on the counts laid out in the complaint would then effectively operate as under tribal law, would effectively be a judgment against Mr. Emery, finding him as violating tribal law in terms of the misapplication of tribal funds without proper authority. And then at that point, that would disqualify him from being an eligible candidate in the future.
All right. So where I'm leading to with this, Mr. Adams, is that I'm going to grant the default judgment for the failure for Mr. Emery to appear. And then that would carry that part of the order that he's no longer eligible to run for a political office for St. Croix. He's disqualified. As far as any monetary penalty now, are we talking, or actually it's not even a penalty, it's more of a reimbursement. Are we talking that that's a decision that could be made at this time, or do we want to wait until after the bankruptcy proceeding is completed?
Well, Your Honor, the difficult position that Mr. Emery puts us in is that by him consciously deciding not to participate in this case, in his defense, I take the standpoint, Your Honor, that you can take the complaint on its face as being true and order restitution to the tribe in those amounts, or Your Honor, I mean, the tribe is fully prepared to file a written motion for default judgment against Mr. Emery, so that we have it properly papered in front of the court. And then, Your Honor, if the court, if it would benefit the court, Your Honor, we would be fully prepared. And I believe we already have filed our exhibits with the court, but we would be more than prepared to file an attachment, to that motion for default judgment, laying out all of the damages that the tribe alleges for the court's convenience to review, with a full spreadsheet and breakdown of the various funds that the tribe alleges were misapplied, that we were fully prepared to put in terms of our case on in front of the court today, Your Honor. We would be fully prepared to provide all of the documentary evidence and a spreadsheet laying out the various amounts, Your Honor.
Okay, so how does that fly in light of 11 USC 362B4, where I quote from your letter, including the enforcement of a judgment other than a monetary judgment?
Well, Your Honor, we would not, the enforcement of any judgment would be a secondary process. So it's one thing, Your Honor, for you to issue a default judgment against Mr. Emery, and then it's an entirely different procedural process by which we would file a writ of execution against Mr. Emery related to those damages. And so what I'm saying, Your Honor, is that I believe the court is perfectly within its right to issue a default judgment against Mr. Emery, and then at that point issue an order against him, but at the same time hold the case in abeyance, so that the clerks aren't accepting any further filings related to any writs of execution until Mr. Emery's bankruptcy proceedings have been finalized in Madison.
All right. So you're also telling the court that you're going to file a specific motion to address this, and that it's going to spell out the entire penalty portion of this result of this action. And then what you're saying then is that there'd be no attempt by the court or by the tribe to collect that until the bankruptcy proceeding is completed in Madison.
Yes, Your Honor.
All right. When will I get that motion?
Your Honor, I can have, the motion is drafted, so I can have it to you, pretty soon after we get off of this Zoom hearing, Your Honor.
Okay. My ruling is this: due to the defendant's failure to appear with proper notice and his attorney not admitting that he's here, the court's finding the defendant, Elmer J. Emery, guilty of violating the St. Croix Code of Laws and the petition that's filed by the tribe. And then right now I'm going to wait for the tribe to make a formal motion to the court. And then upon receipt of that, the court will then respond accordingly. But on the record, the court is saying that by non-appearance, the defendant is guilty as charged in the complaint filed by the tribe against him. With that being said, I just want to let you know, Mr. Adams, that my computer is going to be undergoing some technical services. It was scheduled for this evening, but if he's available to do it, we're going to have him do it today. So I may not get that right away, but I should get it by tomorrow. He's telling me it's only take a couple hours, but we'll see how that goes. So I will respond back with you to that by tomorrow.
Understood, Your Honor.
Any questions?
No, sir.
All right. All right. All right, court's adjourned.
Thank you, Your Honor.
Thank you.
So,
We're still on YouTube.
oh,